Welcome to our new episode of the podcast in Dubio Pro Justitia. Today, I have the honor of having a renowned international criminal defense lawyer, Michael G. Karnavas, practicing law for over 40 years. Michael has appeared before state and federal USA courts, the International Tribunal of former Yugoslavia, the International Criminal Tribunal for Rwanda, the extraordinary chambers in the courts of Cambodia, and the ICC. Michael, thank you very much for agreeing to this episode. To be honored to speak about a lot of things.
Thank you for inviting me.
So we can go straight to the first answer. I think that most people are curious about. How does one become an international criminal defense lawyer?
Well, there are various ways. The best way, I think, is to first practice law in your own home jurisdiction. You know, it's okay to get out of law school, maybe get a master's degree, do an internship at one of the tribunals. But I think the best way to get into this field and to excel is to learn how to practice in your own jurisdiction, where you're practicing regular street crime, white collar crime. Get that sort of experience before you come to the tribunals, because otherwise, if you start at this level over here, most likely you're going to start as an intern and then maybe as a legal assistant. You may spend several years, and then you may get lucky after 6-7 years and get a case, or become part of it, be co-counsel. But effectively, you have no trial skills. You've been watching somebody else do it, but you haven't done it yourself. You haven't learned the sort of strategic thinking that comes along with practicing in your home jurisdiction or doing many cases. So very, very few, in my opinion, can excel having bypassed that stage, because what happens is you're learning on the job. So at this level,
Okay.
Do you want somebody? You as an individual, if you were the accused, would you want a lawyer who is learning how to lawyer in your case, how to be a trial lawyer in your case? The answer is no. So if you wouldn't want that for yourself, why are you doing it for others?
Yeah. But do you think most lawyers, international criminal defense lawyers, for them to get in the mix of the ICC, in this case, in international criminal defense, do they need to relocate to the country of the court? For example, in your case, you live in this moment in The Hague. Did you felt it was necessary for you to be there, or?
Well, I think for me, when I came here because of a case, and because I knew the case was going to take long. And, I was very, very realistic from my experience. I looked at the case and I knew it was going to be a 3-4 year case. So I relocated over here. I don't think that you can, during the pretrial stage, you don't have to be here all the time. It does help to be here as much as possible because your team is going to be here. Because in any case, you're going to have a fairly large team. You're going to have a case manager, you're going to have legal assistants, you have an investigator who occasionally goes out in the field. And so you have to manage that team. The team can't manage itself. You don't have to micromanage, but so it helps being here. Once the case goes to trial, you can't avoid it. It's 7 days a week you're working. It doesn't matter what size the case is. Usually there's that much work to be done once you are in a trial phase.
Okay, interesting. So going back to the beginning, to the ICTY, the International Criminal Tribunal of Yugoslavia.
Right.
You acted as a counsel in various with various clients, different clients. I've read about this case, and some main criticism is the limits of the ICTY lawmaking power, as well the legitimacy, legality, and accountability. Could you expand on? Do you agree with these limits of on the ICC, or your
Okay, the
perspective is
ICC
different?
or the ICTY? Which of the two?
ICTY.
Yeah,
Sorry.
with the ICTY was created, was established by the UN Security Council. So if you're going to look at the ICTY, ICTR, because they were creatures of the UN Security Council, they were truly, truly international in the sense that you had the United Nations behind it. You had the Security Council behind it, and therefore every state had to comply with and was subject to, in a sense, the ICTY. So it was a much more legitimate court, let's just say, than say the ICC. Not that it's not legitimate, but the ICC has 124, 25 states that are members, but the main players aren't members. The United States, Russia, China, India, Indonesia. You go down the list, and so it's a club of 124 countries, and they say, well, this is an international court with very limited jurisdiction. The ICTY was established, to focus primarily on events that had occurred in the former Yugoslavia. You have to understand that before that, we only had Nuremberg and Tokyo. So there was not much to look at. And so they had to establish themselves. And by and large, I think the initial phases, the first two stages, were sort of rocky, as you would expect, because they're establishing the court, they're having to investigate. But eventually, I think at some point, 4 or 5 years into its existence, the ICTY was functioning like a Swiss clock. It was very robust. It had a tempo and a rhythm that you haven't seen anywhere else. The judges were not the best. Some were very, very good, and others were diplomats or academics who had never practiced law before. So I mean, would you want a professor of anatomy in the operating theater doing brain surgery? I don't think so. He might be able to teach the class on anatomy, but doesn't mean that he's a capable surgeon. So there was some of that, but by and large, I think it was a success. Yes, they did create a lot of law as opposed to, let's just say, apply the existing law. But they did it in a way, I would say, that they were trying to expand the contours of the law as they understood, and to build on it, very much sort of like in the common law system, where you build on the case law. Some of it was creative, such as the joint criminal enterprise. That was created out of whole cloth. It didn't exist. But nonetheless, they established that in one case, in the Tadić case. And, if you look at the jurisprudence, which ultimately it was looked at in the Cambodian tribunal, they found that at least for the third type of joint criminal enterprise, it did not exist. And the case law that they, or the authority that they had based it on, was flawed, did not support what they were claiming. But with the ICTY, what they were doing was, they would pronounce a case, a decision. Then in the next case, the same panel would look at its previous decision and say, well, we have authority. And then down the third case, they would look at the previous two cases. And so there was this sort of myth making that somehow some of those decisions were strongly based on the law, when in fact they were just making it all up and relying on their own decisions and to use them as authority.
There are also other criticism of the ICTY of disproportionately targeting Serbs while allegedly being lenient on crimes committed by Croats, Bosniaks, Albanians, and also at the same time that the ICTY was geographically and culturally distant, being based in The Hague and not involving victims of the communities in these processes. Uh, did you felt like this when you were a counsel in this ICTY?
All right. Well, I think it would have been difficult at that period when the court was established to actually have established a court in the former Yugoslavia. And you just mentioned Serb, Croats, Muslims, as they were known during the war, now called Bosniaks, and then eventually Albanians and even Macedonians. It would have been very, very difficult to put a court either in Belgrade or Zagreb or Sarajevo or what have you. So The Hague seemed the logical place. The distance was not that far, to be honest, and I never experienced or saw any difficulty in bringing witnesses over there. They had a very good outreach program. Yes, it's always good to have the trials take place where the crimes were committed. But having worked in the former Yugoslavia, in Bosnia and Herzegovina in particular, I can assure you that at that period, it would have been very, very difficult. So at some point down the road, around 2001, 2002, and later on, I think it became a little bit easier as in Bosnia and Herzegovina, they established a state court. But they haven't had a court over there at that point. It would have been pretty difficult. As far as disproportionately going after Serbs, regrettably, I have to say the answer to that is yes. I think, and I spent a considerable amount of time in Bosnia and Herzegovina, for instance, and in Croatia, in analyzing, reviewing what happened, over there. Yes, the Serbs were, committed crimes, but so did the Bosniaks, and so did Croats. Croats were targeted not as much as the Serbs, but certainly much more than the Bosniaks. The Bosniaks got a free ride, essentially. I mean, I'll be very, very clear about that. There was lots of instances where they should have prosecuted, where they simply, decided not to. And when they did prosecute for very limited, crimes, the charges were very, very limited, which is why I think the tribunal, as far as the folks back in the former, Yugoslavia, look at it as a flawed tribunal. Okay, they see it as one that was disproportionately targeting, one side and not the others. Aside from that, the other major problem that gave the appearance of, let's just say, a disparity in justice is the fact that you had trial chambers that were made up of judges from different countries, some from the civil, some the presiding judge might be from the civil, or it might be from the common law systems. And there was no uniform way of trying cases. And so this was an adversarial procedure that they had adopted. They were experimenting. The procedure was altered throughout. So imagine playing a football game where the rules are being changed as you are on the field playing the game, not even on the halftime, but as you were going, So that was happening. But optically, you would see, because there were 6 trials going on at any given moment, there were 3 courtrooms, and so you would have a morning and an afternoon court. And this was televised. So you could see the disparity. And one, could legitimately say, well, how is it that the Serbs being tried in this court are getting this sort of justice, procedural justice, And here the Croats, or the Bosniaks are getting a slightly different sort of procedural justice. And that's the important thing about international criminal tribunals. It's not just as much important or just as important to have substantive justice. You have to have procedural justice as well. And that's terribly important, because if folks perceive the process to be unfair, even if the result is the right result, it will not be accepted. And the whole purpose of having these tribunals is so the folks back home can get can acknowledge what happened. There's accountability, and there's an acceptance. There's an acceptance of the decision and the sentence that comes with it.
Okay, so and could we go through the Tadić case and how important it was for the future of the international courts? Could you explain a bit more?
Well, the Tadić case is important in the sense that this is the very, very first case, and so.
So the first case law for the court.
Well, yeah, well, that's it. You're going to test everything. A good lawyer, and Tadić had very, very good lawyers, and they did what was expected of them. They had to test everything from jurisdiction onward. So there wasn't a single decision that was made, that wasn't challenged. All the procedure is being challenged because this is all fresh. You have to remember that the judges were sort of given the statute that shows, how the tribunal is supposed to function, but they themselves drafted the rules of procedure and evidence. They got together and said, okay, these are the rules that we want. And, but so both on the substantive law and on the procedure, there were constant challenges. And so how the court decides certain issues at that point, that will have long-lasting ramifications. Because let's just say a decision is made at the trial chamber, then it's appealed. The appeal chamber makes a decision. That decision will stand and will not be overturned unless there are cogent reasons. In other words, another trial chamber has to say, well, they got it wrong, and here are the reasons why they got it wrong. And we find that this is, this is how they should have ruled. Very, very difficult to arrive at that. So Tadić just, sort of set the stage, but that doesn't mean that all the issues were settled, because there's lots of nuance, and so you're constantly attacking and fine-tuning the law on the fringes.
But for me, it seems like it's very difficult for the defense teams to prepare for the tribunal. If the rules are always changing, if case law is being used, like the case law is being created and then used it afterward. So it seems a bit complex in trying to navigate, and the legal teams to try to navigate and achieve the best result for their clients. It seems it's a bit difficult.
Yeah, well, I mean, I think you are quite correct. It is very, very difficult. I was very fortunate. Before coming to the ICTY, I had practiced law for nearly 20 years. I had a lot of experience in the courtroom. I tried, about 200 cases. It's very, very experienced. I had been teaching and trying and training lawyers. And I also knew the civil law system very, very well, because I had worked in Cambodia on the civil law, on the French model, civil law system, and then again in Bosnia and Herzegovina. So I understood how the civil law system worked and the principles behind it. So when I came in, because this is a mixture of the two systems, it's a hybrid system. It mixes both, civil law and common law. And with that background, for me, it made things looked a little bit easier. I could understand them. But you're right. If you're going to start a game with these sorts of rules, then it should finish. Unfortunately, in creating the rules, the mixing and matching, and sometimes without really having an appreciation of the consequences. So if you take a mechanic who only works on diesel engines, that's all he knows, and you get another mechanic who's on petrol engines, they're both mechanics, and you say, okay, now build an engine. And you have a hybrid engine. Now, some things may work, some things may not work. And so it was sort of experimental. That's one aspect. The other aspect that I think is very, very important, and it transcends not just the ICTY, but all the courts, even the ICC. Judges, like the rest of the lawyers and prosecutors, are prisoners of their own legal tradition. So they tend to look at the rules or the statute through the lens of their own legal tradition. But that's not the legal tradition. So they would think, okay, this is how we do it in Germany, so we should do it like this in The Hague. But the rules in Germany are different than in The Hague. But when you're reading the rules, you're reading them as if they were German rules, not this hybrid without it. And so if you don't have an appreciation of the adversarial process, you can't get your mind around it. And if you don't make the effort, it's not going to happen. Now, you have to understand, when the judges show up, there's no orientation. There's no training. Some may never have been in court other than maybe to get a divorce. So they really don't know what's going on. It's a huge learning curve. And what they're told is, okay, here's your robe. Here's the statute and the rules. Here's where you go into the courtroom. Here's how the courtroom functions. Here's where you're going to sit. And that's the extent of it. And then it's up to the judge. Now, some judges were very surprising in that they may have lacked, experience or come from different legal traditions, but they really put an effort to understand the system. Others, however, were incapable. And as a result, you had this sort of, situation where rules are constantly being amended. And then there's every court had its own separate practice, let's just say. So in one court, you could examine the witness for as long as it was necessary, as long as you were not being repetitive or asking irrelevant questions. In others, you had the strict time limitation. So I was in a case where there were 6 accused. The prosecutor would spend 6 hours on a witness, and then the judge would say, everyone has 1 hour for the witness, without giving any consideration as to whether I might need, or one of the accused might need 2 hours or 3 hours because of the nature of the events being discussed with this particular witness. And so you're seeing this improvisation, and sometimes it was rather bizarre to be in a procedure where everything is constantly being changed from day to day to day.
Yeah, it seems definitely tricky. And did you manage to leverage your experience when you were a lead counsel for Dr. Jadranko Prlić, was charged with and tried on the basis of individual and superior criminal responsibility? And how did you try to demonstrate that there was reasonable doubts in the superior criminal responsibility?
Right. Okay. Well, that case, that case stands out in my career, and probably even at the tribunal, as being the worst tried case, with the worst panel of judges that were fighting among themselves, judges who really didn't understand the procedure. One judge, in his 70s, shows up without having ever practiced law in a courtroom. And so it was a constant improvisation. And this is the case where there were 6 accused. And so you had this this environment where it was a constant struggle to put your case forward because of the evidence, the amount of evidence, the data that we had to deal with was incredible. And so the judges, I think, were, aside from being inexperienced and ill-prepared and not getting along among themselves, really didn't know what they were getting into. So initially, for instance, they had given the prosecutor so many, like 200 hours. I can't remember the exact number. And then 6 months into their own case, they cut the hours. And then they said, after they cut the hours, says, yeah, but we'll hear what you have to say. We'll take it under, you can try to dissuade us of the decision we already took. Now you have to understand that when they initially said you have so many hours, the prosecutor planned their case based on those hours. So now midway, you're cutting their hours. That's a monumental problem. I recall trying to conduct cross-examination in a coherent manner so that they understand. And I'm constantly being interrupted. The judges would just take over and ask questions. At the same time, they give you this limited amount of time. Now you have to understand that I show up prepared. I have a plan. When the judge takes the witness here and there, then I have to spend time getting the witness back. So at one point, I reacted very angrily. And then I said to them, we have a procedure. This is all on the record, so I'm not saying something that, was said in private. I said, we have a procedure. If you don't want to follow the procedure, pack your bags and go home. But this is how and if you don't know how the procedure should work, give each side 1 hour to articulate how the case should be, how the trial should proceed. Now, if I were to say that in the United States in a court, they would probably think I was crazy, and I would be locked up. Instead, what happened? They gave each side 1 hour, and we lectured to the judges on how they should conduct the case. Okay. For me, that case was very, very disappointing because in the end, you get to file what is known as a final brief. And in the final brief, we had a limited amount of pages, but nonetheless, it was sufficient, where we pointed out not only the page, but also the lines, all of the relevant material. So we would make a statement, a declarative statement, and then you would have a footnote, and then the footnote you would support it. When we got the judgment years later, some 2,000 pages plus, it was very, very clear that they had not looked at the evidence at all. And one time they said one of our witnesses was not credible, and they would discuss it later on. They didn't say why he was not credible, and they never discussed it later on. What they did was they mentioned every witness, and they mentioned the documents, so that on the appeals, when you went to appeal, the appeal chamber would say, well, they considered the document, they consider what the witness. How can you say that they didn't consider it? They just didn't think that it was credible or necessary or what have you. So it made it almost impossible to appeal. So they disregarded the entire defense case. So that was the Prlić the case, and I think even the prosecution was frustrated, but I think by and large all of my colleagues felt the same, that we were not, that the accused in that case, and specifically, Dr. Prlić, we were able to establish that he had no real authority. he had a position with a title, but that title did not come with authority. Others had the authority. And so we were trying to show that there's no linkage. It's not a matter of, we acknowledge crimes were committed here or there. That's not a problem. The problem is who's responsible. And to my mind, they did not establish guilt beyond a reasonable doubt. And he was treated unfairly, and he should not have been convicted.
So yeah, I think from what you described, even in the way of the witnesses, it seemed like it's a bit of a mix between civil law and common law, because yeah, as of course civil law, the judges are intervene and are the first to ask questions, and if they have a doubt, even when the lawyers are questioning, they intervene and say, give me 1 second, just clarify this. And so it's
right. Exactly. And they were all civil law judges, the whole panel, which was very unusual, because normally you would have a mixture. You would have somebody from, you would have a mixture of civil and common law, so they could help each other. But in this instance, you didn't have that.
So going forward to another hybrid international court, or national international court, the ECCC, Extraordinary Chambers in the Courts of Cambodia. You are also a counsel here, and once again, I'm going to say what were the criticism of this court. No accountability, once again, political influence on the results, 1.7 million victims, but only a few defendants. And there was also a hybrid structure where the UN, with the Cambodia judges, created a hybrid tribunal where there was it was needed that the international judge would vote for the ruling to pass.
Okay. All right. Well, let me. The ECCC, the Extraordinary Chambers in the Courts of Cambodia, was a missed opportunity. It was going to be the model court, and the court that would sort of set the stage from which the state courts, the national courts would learn and adopt procedures from. But they missed a lot of opportunities. The procedure there in Cambodia is based on the French system. Okay, it's modeled after the French. They made some alterations, but by and large, it's the French system. The tribunal took that and made some, and then of course, like the other tribunals, they created their own internal rules. So when it suited them, it was civil, and when they didn't like it, they would adopt some common law or adversarial modalities to it. The judges, you had most of the judges were Cambodian, but you had international judges, and none of them, as I recall, none of them, at least early on, had international experience. They didn't, so again, they're coming with their own, legal traditions and what have you. The problem with the Cambodian system was trying to manage a case of this magnitude, because the events took place throughout the entire country for approximately four years, from 75 to 79. And there was a passage of time, some 30 years or whatever. And now you had this investigative judge approach. Now, prior to this trial, I have to admit that I was leaning towards that model, thinking maybe that's a better model, because as a defense lawyer, often it's very difficult to go into a very dangerous situation, and to try to gather evidence. You don't have the the resources, you don't have the protection. So maybe it's better to have an impartial, investigative judge to do all of that. Well, I think that while that system works very, very well in France and maybe some other countries, it's not suited for large international cases of this nature, okay? Especially if there's a passage of time. Because what the investigative judges did in that instance was validate what the prosecutor had given them. They really never investigated. The prosecutor gave them an introductory submission with documents and authority, and they looked at that, and then they tried to validate it. They never went out to search for witnesses. They never went out to do any real investigation. And so it became a very, very unmanageable process. It took a long, long time, and then there was a lot of improvisation once you got to court as well.
Whenever the defense team believed that there was the need for the judge to investigate these kind of facts or witnesses and call it, would normally the judges would normally accept it, or they would receive it with a bit of disdain?
Well, in order to make an investigative request, you had to submit the background information, the predicate, as I would call it, as to why you want him to investigate. So you have to make a justification, that, we would like you to go and investigate or question this person because of X, Y, and Z. Well, first of all, it's very difficult to make an investigative request of that nature if you're forbidden completely from investigating. The prosecutor had, several years to investigate and to gather evidence, so they don't need to go out. But, for us, how do you make that? But let's just say that you make it, then it's up to the trial. You have to convince the investigative judge that that's actually necessary for your defense, that they may have exculpatory evidence, or that it's relevant to an issue for context or what have you. Of course, whatever you put down on paper also is going to come back to bite you, because you're making an assertion. So it's not like in the adversarial system that you have, this party-driven system at the ICTY or ICC. You may take a chance on investigating somebody, going out, gathering evidence, and whatever you learn may not be to your client's best interest to present, so you don't have to present it. But here you're taking a chance, because whatever the investigative judges find, they obviously are going to use. But by and large, they did investigate, some requests that were made. Most of them were utterly ignored.
Okay. But do you believe that it served the purpose of the courts in the end, with the results, with the sentences? Did they provide the justice that it was needed, or once again lacked?
Okay. Over 200 million was spent on that tribunal. They only had 2 trials. One trial was basically a prolonged sentence, because a sentencing hearing, because the first trial, Doik, who was the mastermind, or who was who controlled S21 tool slang, where the torturing was going on and the killings, and was responsible for about 12,000 to 13,000 souls that were killed. He had admitted to the crimes. He had given lengthy statements, yet it took 6 or 8 months to try the case. They just wanted, maybe this was like a test drive to see how and to work out the kinks before they got to the main trial. The main trial, which is the one that I was in, Started out with 5 individuals. My client passed away in the middle. His wife was one of the accused. She did not go to trial because by that point, she dementia had set in. And so, so there were 4 individuals actually. So anyway, the trial took a very long time. They severed the case because it was a large case, and they were worried, I guess, that that they would lose more accused, so they severed the case. So the trial ended up taking almost twice as long as it should have taken. And as I said, there was a lot of improvisation in the way they conducted the trial. So from a pedagogical point of view, I don't think that much was learned that can be transferred to the national stage. When it comes to, for instance, what decisions that were made regarding human rights, fair trial rights, those procedures, the national courts have essentially said, we don't recognize whatever that tribunal did because that's international and we're national. So unless the Ministry of Justice decides to, at some point, to say, well, here they articulated why an accused has the right to examine, or whatever the case may be, the national courts are not going to look to whatever was accomplished in that tribunal. So from that point, that's another one of those losses. Was there political interference? Well, it's difficult to comprehend how the events that took place over 4 years in a whole country where, 1.7, 2 million, whatever, nobody really knows the exact figure, and you only try 5 people, for 200 million. The big issue, there were other cases. There was case number 3 and case number 4. I was also involved in case number 3. The issue there was, were the accused, did they meet the criteria, the jurisdictional criteria of being one of the most responsible? Okay, because the first trial, you had Doik, and then you had the trial of the leadership. Their position was very clear. There wasn't really a contention as to whether they held leadership positions. And then you had whether the others were most responsible. And so that was the whole issue. So you had protracted litigation, and in the end, while the international judges, investigative judge, and then the judges on the pretrial chamber found that yes, some of them, all but one, met that criteria, and the case would go forward. The national investigative judge said no, as did the national pretrial judges. And of course, the Supreme Court, the last instance, agreed. So it was a stalemate. But what had happened was they had created in negotiating this tribunal between the United Nations and the government of Cambodia, they adopted a procedure that was set for gridlock, where at any given point, the nationals could stall or basically bring the procedure to an end, and that's what happened in that instance. You had this gridlock, and there was no way of breaking the gridlock, and so in the end, there was no trials in case 003 and case 004. And by that point, I question whether there was an appetite by the international donors for those trials to go forward, because then they would have to spend another 3 or 4 years, maybe 5, financing that court.
Yeah, 200 million for 5 cases, and then only 2 get tried. It's
Yeah.
doesn't seem as that efficient and accountable, and the accountability seems lacking in because for 100%, from what I read, there were much more perpetrators from the Khmer Rouge, but from the group that committed those crimes, but some deflected, and there were also instances where, from what I read, there was a policy: if they left the group, they wouldn't be criminally responsible for certain crimes. So it seems.
Well, I mean, I think the issue there in negotiating who was the most responsible, you have to understand that when the Khmer Rouge were ultimately kicked out of Cambodia, there were, it wasn't just the Vietnamese. There were former Khmer Rouge cadre who had defected to Vietnam, and then they came, and then eventually they're the ones that took over and have been in power ever since. You know, the Cambodian People's Party. You know, and you had members, you know, in that faction that you know, that had been involved or were situated in areas where crimes were committed. And so logically, you know, for self-preservation purposes, you know, they didn't want these international judges to now go, you know, on a fishing expedition to try to see whether any one of them may have committed any crimes. They wanted to contain it, to have a very limited process, and a very controlling process. And so in negotiating, and the United Nations was very well aware, at least Kofi Annan was, that there was a potential of this procedure resulting in gridlock. But nonetheless, there was a great deal of pressure to go forward and to do something as opposed to doing nothing. And so you have that. Now, having said all of this, I think the legacy of the tribunal has been rather positive in respects that folks, you know, in Cambodia, some of them think that they did get their day in court, because you would have these, you know, like one day you would have Buddhist monks, another day you would have the Cham, another day you would have this other group coming in. And you also had civil law civil party participation, you know, victim participation. So a civil party such as the Cham had their lawyer in court, and they got to ask questions as well. So they felt that they were part of the process. And since then, I think there's been a lot of effort to sort of educate the entire population on what happened, the ongoing events. There's a legacy project going on as we speak. So from that aspect, yes, there were some positives, but could it have done better? The answer is yes, absolutely.
Okay. So going now forward to the future and to the present day, and to talk about the ICC. I think the most recent events are the ICC arrest warrants for the Prime Minister of Israel, Benjamin Netanyahu, Yoav Gallant, as co-perpetrators for committing war crime of starvation as a method of warfare, and crimes against humanity and other human acts. And we have seen that after these arrest warrants were issued, a lot of member states of the ICC, of the Rome Statute, have been saying that they won't arrest Benjamin Netanyahu because of, on the basis of the Article 98, because they have international obligations to the state, and it's the head of the state. I would like to comment on this, please.
Right. Well, I think this is going to be a watershed moment for the ICC. I think that one of Israel's main objection is that the Palestine should not be a member state of the ICC. So on a jurisdictional ground, if Palestine is not a member of the ICC, then any crimes that were committed, in Gaza or West Bank or what have you, could not be tried at the ICC because the ICC has no jurisdiction, because crimes would have been committed by and on non-member states. Palestine, this issue, however, has more or less been resolved, although it's going to be attacked again, and that is whether, because of the Oslo Accords, whether the ICC or whether Palestine could join the ICC. This issue has been litigated, and the ICC has already indicated that Palestine is a full-fledged member. So if crimes were committed on Palestine, on that territory, in Gaza, for instance, then the ICC would have jurisdiction. Likewise, if crimes were committed by Hamas in Israel, a non-state party, because the crimes originate from are committed by residents of a state party, Hamas, those people are subject to the ICC jurisdiction. Okay. Karim Khan, the prosecutor, had been very, very clear early on, that everybody on all sides, they have to abide by the laws of war, And in particular, at one point, I think when he went to Cairo, he made a speech, which was very Churchillian. And, he more or less warned that, consequences would flow. One of the main issues had to do with humanitarian aid, whether humanitarian aid was being used as a weapon. In other words, being withheld, which would cause a starvation in a sense. And so, which is impermissible. The other side, I'm sure, has, the Israeli side is saying, well, it wasn't that we didn't allow aid, but the aid was being stolen, and so on and so forth. We're not responsible. I don't want to go into the merits because I don't have the facts, and I don't think that anyone can say with any degree of certainty that there's proof beyond a reasonable doubt that Netanyahu and Gallant are guilty of whatever charges are the basis for the arrest warrant. Okay, because in order to get an arrest warrant, all you need is reasonable grounds. I know that the Karim Khan had some experts. Some may or may not necessarily fall within that category. Certainly, maybe not objective. They were not necessarily objective, but nonetheless, they looked at the evidence and they said, yes, I think there's enough there to reach a conclusion that there are reasonable grounds to submit this to the pretrial chamber, and it doesn't mean that later on, if the case proceeded, that they would find that there are substantial grounds to confirm the charges, which is the next step.
Yeah, but at least there are reasonable grounds. Yeah, that's the
right. But there's at least reasonable grounds, right? Now, while this was being, it was even before the arrest warrant was issued, you had rumblings from Israel, from Netanyahu and Gallant, but Israel, more or less trashing the ICC for even investigating this, that they had no jurisdiction, that this was anti-Semitic, that this is biased, that they should not do this, and so on and so forth. The United States, at the same time, began also a campaign, if you will, saying that the ICC should not do that, that this was outrageous, that there was some sort of a false equivalency, that how can you equate Israel, Netanyahu, Gallant, and others, and what they're doing with what Hamas did? Well, it's not about comparing. all sides have to abide by international norms. Okay, so it doesn't necessarily, just because you're defending yourself doesn't mean that you have carte blanche to commit whatever crimes you wish. I mean, even in a national context, to just put it very simply, let's just say you attack me and I exercise self-defense. Okay, legitimately, I'm in fear. I use a certain amount of force. I defend myself. That's okay. The law permits that. However, if I were to use excessive force, or after there was no longer the need for self-defense. Now, Israel, I think rightly can say they still need to continue their attacks against, Hamas, because they continue to pose an existential threat to Israel. Because, today the guns may be silent, but tomorrow they may do the same thing. So from that standpoint, I don't think that there's much confusion or disagreement, but how you go about defending yourself,
Yeah, I think
that's the important aspect of it. Okay, and so now you have the arrest warrant is issued by the prosecutor. Now all of a sudden there is this panic, among certain members of the ICC, France, Germany, Italy, all these Western states that support Israel and certainly do not want to be in a position where they have to arrest Netanyahu or Gallant, because under the ICC statute, under the Rome statute, their obligations, they must arrest and they must transfer somebody who's under, an arrest warrant to the ICC. Okay, and it's one thing for al-Bashir to be in Sudan. He's not going to go. He has no need maybe to go to Norway or to Paris or to London or whatever. But now, by imposing this arrest warrant, restricts Netanyahu's ability to travel. Okay, and that's very.
I think that's the main. It was the main objective. I think that's the reason why the states are even the US and the pressure. Yeah, they are panicking, and they have the US is completely on the side of Israel for the good and for the bad. So the conditional support. Unconditional support, and I think most states are a bit afraid, but at the same time we have the ICC, they are member parties.
Yeah, I understand that, but there was a letter that was sent even before the arrest warrant was issued, where Senator Cotton, U.S. Senator Cotton, Republican, very, very conservative, and it was signed by, I think, 3 or 4 other members, Republican members, said to Karim Khan, you are warned. They were warning that in the event this process go forward, there are going to be sanctions. Now, it's one thing to sanction Karim Khan. So Karim Khan and his staff cannot travel. They have, you make their lives a little bit, difficult. Although I still think that they can go to New York to the UN sessions. But it's another thing to sanction the ICC as an institution, because that means that anybody doing business with the ICC would be sanctioned. So now you got banks, you got, like Microsoft, you got all these vendors who are doing business with, and the ICC relies on, and they would be sanctioned. So that could have a crippling effect on the ICC. So now they're at this watershed moment. Do we abide by our obligations under the Rome Statute, or and suffer the consequences of the U.S. sanctions, or do we find a creative way to say, no, we don't have to make the arrest? And I think that's where we are today.
But
You
can
know, you have
a non-member
the
state, non-member
yeah.
state, as the US is, have this amount of power that can completely crumble International Criminal Court? We do have,
Well,
but it's a
yeah. I
bit
mean, if
worrying. Yeah,
yeah, if Botswana said, you know, or some small country said we're going to put some sanctions, nobody would give a
yeah.
give a thought to it. But it's the U.S. that says that, and they don't want to be on the wrong side, which is why you had France just recently, you know, when France initially said that yes, they would comply with the arrest warrant, then they changed their mind and said, well, no, there's no that Netanyahu enjoys immunity, and they would not arrest. Because why? One, you know, the sanctions, but two, also Israel said, well, if that's the case, you should not be participating in these peace negotiations between, you know, Israel and Hezbollah. So these states are coming under a great deal of pressure, and now they're trying to find a creative way to get around it. So Israel, in the meantime, has said that they're going to appeal. They're not appealing the arrest warrant per se, because at this stage it's premature. Okay, there's no way to get to the appeals chamber on that issue. So what they're appealing on the jurisdiction, that overall the IC had no jurisdiction whatsoever, and therefore, you know, Israel should not have been investigated. The arrest warrants should not have been issued.
So
And
they
we'll
will
see whether
attack.
we'll see. And that might be the silver lining for the appeals chamber. They may come and say, well, yeah, you're right. But in order for them to do that, they would have to disenfranchise Palestine. They would have to say, okay, now you're no longer a member state.
Or
But
you aren't even a state. That's the silver lining,
well, yeah,
because
but
that's what they want to attack. Because if Palestine is not a state, they don't have a place as a member state, right?
well, you know, you have to understand that the ICC doesn't need Israel to tell them what, you know, who they're going to accept and who they're not going to accept. The ICC has certain criteria. They say that Palestine, such as it is, even though it's not, you know, a member state of the United Nations, for instance, they are recognized as having all the qualities and meeting all the conditions to become a member state, becoming a member, let's just say, forgot the state, become a member of the ICC. Israel saying, no, they not only they don't meet that criteria, but the Oslo Accords forbids Palestine from joining the ICC. And so now the ICC appeals chamber has to make a decision. At some point, they're going to have to make a decision. Well, is Palestine a member of the ICC or is it not? I don't think they can say they're a member for everything else except for Israel. If they say they're not a member, then I think that's going to, you know, how is it that all these years you treated them as a member? Okay. So I think in the end, it's going to be very, very difficult for them to make that decision. What I suspect might happen is to find some creative way to say that in the interest of justice, the arrest warrant should be parked, should be set aside for now, should lay dormant, or maybe even dismissed on the grounds that, well, we have no capacity to go to Gaza or to Israel to investigate in order to gather evidence required for the case. And therefore, since it's an impossible situation for us to deal with, in the interest of justice, we're just going to park it. and that sort of solves their problems. But if they do that, it also shows that they're caving into the United States. It shows that
Double standards.
There's two sets of justices, and so far, the criticism is that the ICC has been an African court, that it targets only Africans. It might investigate others, but it never does anything with the others. It's just, they're just willing, they just want to prosecute, or they just end up prosecuting Africans. And those who they think, those with power and authority, like the United States in Afghanistan or Israel and in the Gaza, are off limits.
And what about open source evidence? Because we have seen from this, even if the ICC cannot go to Gaza or go to Israel, we have now open source evidence from journalists, daily information, daily evidence, bombings, various and numerous informations and evidence. Can it be used from by the prosecutor and by the pre-trial chamber?
I think that they're using much of that. They're using already for the arrest warrant. They probably are going to use some of that for the confirmation process. You have to understand, with open source evidence, you have to be very careful because some of it may not necessarily be reliable. Some may be, AI generated, some may have been tampered with, how it was collected, the source of the evidence. There's all sorts of legal issues before you could use such evidence. But let's just say you have a trove of evidence that you want to use. Now the question is, well, how do you use it without having a defendant in the court, without the accused being there? So the only other solution, you could have a trial in absentia. Well, they've already said that they will not. They could, in theory, say, okay, we may not be able to try these folks, but we're going to have a confirmation process. We're going to see if there's enough evidence to meet the substantial grounds, which is much higher, and let the public decide whether these folks should be tried or not. Okay. Now, recently, the ICC made a decision in the Kony with Joseph Kony, who's been at large out in Uganda for the last 20 years or so. And so they decided they would have a confirmation process in absentia. So the ICC appointed a lawyer to represent his interest. And at some point, they're going to present that evidence in court, and the judges will make a pronouncement whether there's substantial grounds for, and confirm the charges. They do that for a couple of reasons. One is to preserve the evidence, because some folks, some of the witnesses may be getting old and may pass away. And I think the other thing is to memorialize it and to also put some pressure on the international community to show that this person really has committed the crimes and therefore should appear in court. So if anybody could capture him, bring him over. I highly doubt that they would do that with Netanyahu and Gallant. Why? Because of the sanctions. There would be such severe repercussions. I mean, right now, even before the pretrial chamber made the decision on the arrest warrants, 6 U.S. senators, 3 Democrats, 3 Republicans, sent a letter saying, hold off on that. Let's just wait until the investigation on Karim Khan's sexual abuse allegations, for that sexual harassment, sexual or whatever it was. Now, and of course, that didn't happen. The case went forward. Now those allegations are out there. They're being investigated. We don't know what the result is. But I think the hope was, and I know that it seems that the office of the prosecution is saying that the Israelis are the ones, that are creating this misinformation, are creating this situation. But I think the hope was that if you could remove Karim Khan from that position and install another prosecutor, that other prosecutor would look at it and say, well, I don't think that there are grounds, reasonable grounds to proceed, and withdraw the arrest warrant. And that still might be their hope, because I know that there was talk that Karim Khan should step aside, at least temporarily, until this issue is resolved. Were he to do that, whoever would be acting would have the authority to say, you know what, I'm withdrawing the arrest warrant. It's not worth it. So there are all sorts of political machinations that are going on behind the scenes.
But in that case, would they also remove the arrest warrant for the Hamas leader, Mohammed Defi?
Well, no, of course, definitely they would
of
not.
course. They would not, of
They
course.
would not. And and now I think the question is, will there be pressure to remove the arrest warrant on Putin? Because if Trump says that he can solve the war in one day, of course that's ridiculous. But for certain, I think as part of the negotiations, Putin is going to be demanding that the arrest warrant go away. And if that is an inconvenient obstacle to reaching a final resolution, I think that would happen. And if that were to happen, that would be, sufficient proof to show that the ICC is a toothless tiger.
And it would render the ICC completely useless, and
I think
undermine completely.
It would undermine its credibility, because it already suffers, because it has only targeted Africans. Now you have an investigation in Georgia. Well, those are Russians. They're never going to appear. You're never going to capture them. You have in Venezuela. Good luck in bringing Maduro over here, unless some miracle happens. You have things. You have the Philippines again. So all these investigations and all these cases where it is virtually impossible to get those people over there. So then the question becomes, well, if you're investigating and you're charging folks that you cannot get, and the ones that you can get, you refuse to proceed for political reasons. I think it does, in the long term, undermine the credibility, which is why I think the future of international criminal law lies primarily in the national jurisdictions under universal jurisdiction, where when they capture somebody, if they find somebody on their territory, they try them. So far we have seen the trials are fairly credible, and I think between that and maybe some regional courts, I think that's what's going to happen. But I think the ICC is slowly showing just how fragile it is, and now we're seeing states that are the stalwart, supporters of the ICC, liberal democracies, Western countries, who are literally twisting and turning the law in a way in order to avoid their legal obligations.
But even in the ICC Mongolia case, where Mongolia had Putin over in their country, and as Mongolia is a state party, member party, it did not arrest Putin. The ICC said that from a systematic point of view of the Article 98 does not and could not undermine Article 27, where it states that head of states have no immunity, even current head of states. So I think this, as you said, this argument has already been litigated, and it has already been resolved by the ICC, that it interprets the ICC, the Rome Statute, as it can issue arrests to head of
Right.
states, and the states have the obligation to comply and fulfill their obligations. Right.
Well, in the Bashir case, in the Bashir case, they held that under customary international law, there is no immunity. Now in the Mongolian case, with Mongolia, and it's just a pretrial chamber there, so it hasn't gone to the appeals chamber. They said that under the statute, it's forbidden. Under the statute, they don't have immunity. So you have two different approaches, but basically the same conclusion, that there is no immunity. So what are they doing now? The pretrial chamber has decided, okay, we're going to refer the matter to the Assembly of State Parties, which is going to meet, down the street from my house starting tomorrow. What are the Assembly of State Parties going to do? What can they do? They cannot. Well, first of all, Putin came and left Mongolia. What are they going to do? Kick Mongolia out of the ICC? I mean, if they start doing that, every time a state decides that they want to leave, like Philippines or what have you, they fight tooth and nail to keep them. So I doubt if they're going to sanction them to the point where we say, well, now we're going to kick you out of the ICC, especially when they have a sitting judge. There's a Mongolian judge that was just installed a few months ago. So it just shows you that there's no enforcement mechanism. You can't force a state to abide by their obligations. That's the problem. Where
that's a problem with international law, right?
Yeah, with the ICTY, at least, you had the Security Council, see? And so that's a much more powerful force.
But you cannot have the Security Council determining anything here, because you have the US, you have Russia.
Right.
So
the
hands are tied.
It. Yeah, that's it. But also the ICC has nothing to, the Security Council has no control over the ICC. And not only that, but if you want to show just how dysfunctional the system is, it was the Security Council that made the referral to the ICC for al-Bashir. But members of the Security Council, or the Security Council, refuses to really assist the ICC concerning Bashir.
So double standards, as I see, and the most and once again, I think we are going back to the same thing: is justice and accountability. Is there accountability for crimes if some powerful states are allies with the country itself, or it's even the big countries that commit those crimes? Or it's once again going back to the African countries because it's easier to prosecute and it's more it's agreed that if a person commits crimes, okay, you can charge, you can prosecute a head of state because there's like less political rumors. And now back to the universal jurisdiction. As you said, you believe it's the future of prosecuting these kind of crimes.
Right.
How long do you believe it will take for universal jurisdiction to almost reign and be the main weapon against these kind of crimes?
Okay, well, let's just say, if you're looking at Western Europe, France, Germany, Norway, Sweden, Italy, Spain, Portugal, I think depending on who is the accused, I think if it's from Syria, for instance, there wouldn't be a problem. If it's from Myanmar, there wouldn't be a problem. If it was a Russian, I think most of them would not have a problem with that either. So I think for a state proceeding on universal jurisdiction is not going to be a problem. I think the main question that some have, and I think it's a legitimate question, is how uniform will the trials be? How uniform will, not necessarily procedure-wise, but in affording, fair trial rights, in ensuring that there's both substantive and procedural justice. In the application of the law, their interpretation of the law. Okay. Now, if they're members of the ICC already, they certainly can look to ICC jurisprudence for guidance. But by and large, what we see at the national level is that national courts function, and they function in a uniform fashion. They tend to be very, very good. And so I don't have a problem. I don't think that there's going to be a problem, at least in Western Europe. Whether universal jurisdiction will take root elsewhere, like in Latin America or in Asia or in Africa, that's a different story. They may resort to, regional courts, but even in Africa, we're seeing that, countries are willing to prosecute. So I think this is sort of catching on. I think it's an acknowledged, it's pretty well acknowledged that universal jurisdiction is legitimate, and that you can prosecute someone having committed crimes elsewhere, even though your citizens had nothing to do with it. You were not touched.
But how do you guarantee? Because it's once again, it's easier to prosecute a Syrian world leader, warlord, or Iranian or African. But if it's again going back to for example, the Prime Minister of Israel, Benjamin Netanyahu, or the former Minister of Defense, would once again, it wouldn't once again go back to the same thing as the US and their allies would say. If you prosecute this person under universal jurisdiction, we'll put sanctions on your country. And so they will feel almost obliged to stop, or else the economy may crash. Or
Right. Well, I think if it's if we're talking about Netanyahu and Gallant, if they're arrested on soil of a state that is a member of the ICC, they are obligated to turn that person over to the ICC. So they don't have to worry about trying them. That's not the problem. So I don't see that. Let's just say, however, that they traveled to a state that was a non-party. Okay, let's just say that somehow it was Indonesia. Okay, not a member. Just hypothetically speaking, Indonesia could decide to try them on the basis of universal jurisdiction. Now, I think it's naive to assume that the U.S. would not put severe sanctions on Indonesia. Whether Indonesia could withstand that or not, that's a different story. But yeah, I think we're back to having someone as powerful as the United States being able to dictate whether someone should be held accountable for crimes that are, mass atrocity crimes, war crimes, crimes against humanity.
So, what's the future for international law?
Well, I think we're watching it as it unfold as we speak. I think that international criminal law is here to stay. I think that over the last 30 years, there's been a tremendous amount of progress and acceptance of international law. I think that that the emergence of the various tribunals have proved that that most countries are against impunity. I suspect that you're going to have more and more, as I said, universal jurisdiction trials, but you also may have more and more ad hoc tribunals that are targeted, for a limited purpose, with a limited lifespan. And I think frankly, I think those work best because let's just take Ukraine, for instance. There's so many crimes being committed over there. The ICC is only going to be able to try one or two people. Where are the risks going to be tried if they're captured? They're either going to be tried in Ukraine, and who knows what kind of trials they're going to get over there, or they may be tried someplace else. So the ICC is very limited in what it can achieve. It's trying to be everything everywhere, and it turns out that it's being nothing to no one. It's slowly showing that, over 20 years, and you have what, five guilty judgments. That's not exactly a success story. So I think the future is international courts, regional courts, ad hoc courts, but I don't think it's dead. And yes, there is double standard, but I think the hope is that slowly, as things progress, things will change. And at the end of the day, some justice is better than no justice.
Yeah. Great closing statement, Michael. It was a pleasure having you here. This was a very interesting conversation. For the people that are listening, thank you for also listening to this episode. Follow us on the social media, LinkedIn, Instagram, Spotify, and YouTube. And thank you very much.